Legally Speaking with me, Tarun Nangia. A bench comprising of Chief Justice of India, Justice Dhananjay Chandrachud, Justice J.B. Pardiwala, Justice Manoj Misra has cautioned public authorities not to try and wriggle out of contractual obligations. It also restored a contract that was unilaterally cancelled by a public authority in the state of West Bengal. And the statement that the bench gave was that we are of the considered opinion that this is a classic textbook case of arbitrariness. It has warned public authorities not to be arbitrary, and the advertising contract for 10 years, which was cancelled, has been restored by the court, saying, which is very good music to our ears, only because the ranking of India in the enforcement of contracts is one of the lowest in the world. And when the Supreme Court takes up such issues, it's like taking the bull by the horns and delivers. It reassures investors and businessmen putting money in India that the Supreme Court will stand by your rights in case there is arbitrariness on the other party's part. That said, let us begin. We have a panel of experts joining us today. Let me welcome Senior Advocate Seshadri Naidu on the show. Good to see you, sir. He's a former judge of the High Court, where he was in the Telangana High Court as well as the Bombay High Court. Now he's a senior advocate at the Supreme Court of India. Good to see you, sir, and thank you for your time.
Thank you. Thank you.
Thank you. I have with me Shravan Shankar. He's managing partner of an B. Shankar LLP and also an AOR at the Supreme Court of India. Good to see you, Shravan, and looking forward to some interesting insights. We have with us Manmeet Singh, who's partner litigation, which is dispute resolution practice at one of India's leading law firms, namely Saraf and Partners. Good to see you, Manmeet. Thank you for your time and looking forward to some interesting insights on this issue from you. At the outset, let me request Justice Seshadri Naidu / Senior Advocate for his opening comment. Over to you, sir.
Tarun, thank you for making me a part of this program. Indeed, the subject, that is contractual obligations and public law remedies, is close to my heart. And in fact, this is a wonderful judgment, high time. Just we look forward to that one. You know, when it comes to the facts of the case, I wonder whether it is a peculiar case or a gross case. You know what happens? A contract was awarded. Down the line, within a month's time, they say that we are taking it back. You know, the reason they have assigned, they say the contract is non-specific, and then they say that it's not well-defined, and it's ambiguous, and it results in losses. And they say that we are ready to reimburse. It is the contract they made. You know, the principal contra preferentum, you make the contract, you're bound by that one. You can't wriggle yourself out of that. And despite that one, they do it. And the oppressed party goes to the court. Unfortunately, the Calcutta High Court, it says that, yes, no principles of natural justice have been violated because you have been given a notice. And then it's a policy decision they have taken. And that apart, there is no public law element involved in it. And that's what they have decided. As rightly pointed out by the Honorable Supreme Court in a well-written judgment, they have forgotten the fairness in action, the facets of Article 14. That's why it's high time. You know, any practicing advocate, my other two participants could vouch for that one. Whenever you are faced with, say, cancellation of a contract, either at the stage initial or after the award of the work, for whatever dispute, you obviously invoke Article 226 and go before the court. Then the government, the council, whoever represents, they're bound to though. They come and say that, yes, you got a civil court remedy, go. And then it's decades down the line, you could see the fruits of it. Then afterwards, it's decades down the line, you could have it realized. So obviously the party who has been right and who has been at the receiving end could have the shortest method possible. And after all, we have been telling quite often, that the courts have been telling quite often, when it comes to the imposition of any limitation vis-a-vis Article 226 is only a self-imposed one. That's why it's a timely one. And indeed, it's a wake-up call for the executive as well, or the bureaucracy for that matter.
Thank you for your opening comment. I take this to Manmeet from Saraf and Partners. Manmeet, I request you to explain the case, give your opinion on the cancellation of contract which was restored by the Supreme Court of India. Over to you.
I would start by, of course, Tarun, thanking you for inviting me on the show. As Justice Naidu said, I think this is a case which was quite shocking in the facts of the matter. Also, I think we are today facing a lot of litigation which arises from arbitrary action. And the standard defense which is taken is that there is an arbitration provision. Of course, now the government seems to be walking back from arbitration as a remedy. But the standard defense is taken, the civil court remedy is there, arbitration provision is available. Why are you coming in 226 in writ jurisdiction? I must take you back to the decision of Supreme Court in Unitech versus Telangana State Industrial Development Corporation, where Supreme Court in similar circumstances, of course the facts were different, but similar circumstances where the decision was arbitrary, had held that no, 226 would be available wherever there is a decision which is unreasonable and unfair. 226 remedy would be available, notwithstanding the availability of civil court remedies. Now, of course, where the decision becomes very fact heavy, where the court has to consider evidence of whether or not there was breach, which requires a trial, those kind of matters, it may not be possible to examine in writ jurisdiction. However, matters such as this, where there were clear file notings which were available, which showed that the decision was in fact not made in public interest as it was purported to be, that there was a policy change, the contract was non-specific, and therefore it was in public interest to go ahead and terminate the contract. Now, what this decision does, this decision would now mean that High Court sitting in 226 would be far more amenable to examine issues whether in the facts of the case, is there a breach which is really made out, or is it a trumped up breach? Is it been set up only to defeat contractual rights? And in matters like these, I think the courts must go a step further and impose cost. This was, in my view, a fit case where, of course, Supreme Court has very rightly protected the private participant and held that the decision to cancel the contract was set aside. But in facts such as these, where the decision to terminate is egregious, I think it is time that courts start imposing costs. The private party would have certainly suffered losses having had its contract terminated and had to go through 3 rounds of litigation before it could get justice. So yes, I think this decision goes a long way in protecting private participants' contractual rights. As you said, our contract enforceability is very poor. We need more decisions like this, which protect the sanctity of contractual rights. But now the time has come where we must start looking at the economic implications of decisions such as these, which affect business. For all you know, if the private participant had taken a loan to fund its participation in the contract, this is not a contract perhaps where there was too much capital investment, but there could be cases where the company goes into default, the bankers take the company into insolvency, and then there are implications of all of this. Personal guarantees get invoked, and you are well aware of how infrastructure contracts particularly have, a lot of them have ended up in unnecessary litigation, and people have suffered. Private sector in India has suffered. So I think this is a good opportunity for India as a jurisdiction and Indian courts to start looking at economic implications of some of these decisions and start awarding costs so that the counterparties think twice about taking actions like these.
Thank you, Manmeet, for your opening comment. Now, in this contract that was restored by the Supreme Court of India, this was a contract for maintaining 2 underpasses on the Eastern Metropolitan Bypass in Kolkata for 10 years. Supreme Court indicated that the contracts were unilaterally cancelled at the behest of the minister and also warned public authorities from doing the same. In this case, in the bypass, the party was allowed to place advertisements inside and above the underpasses. And of course, for that, he would have to take some construction and maintenance work both. Despite having given the contract for 10 years to maintain those underpasses at the behest of the ministers, as the Supreme Court indicated, it was cancelled. Supreme Court sent a strong message that, private parties can be rest assured that if a public authority acts in a way that is not in keeping with its contractual obligations, the Supreme Court is there for you. It is a very reassuring decision from the Supreme Court. We will go to Shravan Shankar for his opening comment. Over to you, Shravan.
Thank you, Tarun. So, Tarun, before going into the sanctity of public tenders, which has been enunciated in this very judgment very clearly, I would like to just take take through the facts a little more. Like you said, that once the contract was given with respect to maintaining 2 underpasses, within 2 months, the same contract was taken back to say that from A department, the in charge has been put to B department. And there was an internal note, which is perhaps one of the most significant part of this judgment, which said that there has been a change in policy. Therefore, we can change the contract to another bidder. While the original contract did not have such a clause saying that if there is a change in department, we have a right to retender the whole contract. So while all of this went through, the writ court in Calcutta has said that while denying to exercise writ jurisdiction, said that the administrative exigencies, change in policy, read with jurisdiction not being conferred to the High Court to deal with contractual matters, they dismissed the writ petition. While it came to be dismissed by the appellate court, the Supreme Court essentially did 3 things while passing this judgment, while restoring the contract back to the original bidder. First, they defined the scope of judicial review, demarcating private law and public law policy with respect to the discretion of executive in private capacity and public capacity, and 2, with respect to putting a test for arbitrariness. Say, for example, if a contract has been cancelled in terms of the contract, tender contract terms, then you cannot go to the writ court. You have to go to the civil court. When it is beyond the scope of the contract, when the test of arbitrariness, unreasonableness, and unfairness come in play, which is subject to facts and circumstances of a case, then you can go it. A little further, the court has gone to say the scrutiny of the reasons given behind the such a decision have to be gone into to determine the test of arbitrariness. And lastly, most importantly, the court has gone to clarify one very important and significant aspect. There was a huge debate with respect to multiple case laws coming in play to say you cannot rely on internal notings of a particular department as to why they have arrived at a decision. Now the Supreme Court has very clearly clarified that once the decision is made in public, the court can go into the internal notings. Because in this case, the internal notings very clearly demonstrated that the minister in charge was the authority who was calling the shots. And what is very interesting is that though the department sought for a legal opinion, before the legal opinion came, they gave the contract to somebody else. So that is very interesting as to what a hurry which was exercised in this particular in this particular decision of the government, and very rightfully so, as Justice Pardiwala's judgments are very bold, groundbreaking, and very clear. It's very crystal clear as the law today is.
Point well taken. One thing that we noticed that the arguing counsel representing that public authority in the Supreme Court, he mentioned that now that the contract has been awarded for maintaining the underpass to other party, the original awardee can be compensated. So this is a atrocious statement that, unilaterally you take the contract away, and then you have the gumption to tell, anyways, it's his right as a counsel to represent his client, but to tell the Supreme, now it's awarded to him, so he can be compensated, his whatever fees submitted by him can be returned. These arguments, of course, the Supreme Court, it was not convinced. Now, if you go to the root of public authority contracts with private parties, we see that the court in the past few years have been taking a strong stand, which should ensure that foreign investment shouldn't be driven out of India on account of a fear that if your opposite party is any public authority or the government, then you've had it. They will also award the contract and then try to bully you according to their own whims and fancies, depending on who's in the seat that day. Given that as a fact, how important is this judgment? I'll go across to Senior Advocate Shashadri Naidu for his comment. Over to you, sir.
Well, Tarun, you have raised a very important question. Let me put that in perspective. It's quite natural and it's almost quotidian, a daily occurrence in high courts that the contracts government does enter and then it cancels them for whatever reason, and the party that's been aggrieved comes to the high court and files writ petition. And of course, the government wants to follow the path of least resistance, and it says that as you said, that it's been awarded, work has been half done, and then yes, he can go for a civil court and then claim compensation, damages, whatever. Here, at least they have a semblance of justification in saying that yes, we are willing to pay you back, whatever, subject to other things. This is the one. But please remember, there is one practical difficulty in adjudication of these matters in high courts. Article 226. In one of my judgments at the earliest, I wrote that a judge's burden, a high court judge's burden under Article 226 is called a Sisyphean burden. A Sisyphean burden means it's a Greek character in mythology where he cheated death and remained alive forever. He was old though. And then the gods that be curse him, saying that a big boulder of a rock was given to him. He should push it up the hill. Once it reaches up the hill, he would be relieved of that curse. And he pushes all through in eternity, and it is almost there. Up means it would roll back. That's how adjudication under Article 226 happens. You please see, even in this judgment, if you take precedents as a matter of guiding principle, you can have, say, 100 judgments saying that it can be thrown out, and 100 judgments saying that no, it should be looked into. So this is the what you call quagmire the high courts have been dragged into. And we always say that it's a self-imposed restriction. And sometimes jocularly the judges say, anyway, whose self-imposed restriction? Not ours. So this is the problem where, but this is a case that stands out. I do accept that one. And in fact, the judgment has clarified in such a lucid manner, taking, as it calls, the initial approach of mid-70s as a simplistic approach, and then down the line, beginning from mid-80s or early 90s, as a dynamic approach when it comes to public law adjudication. And court has said that, yes, it is not only public law element, but also an element of public interest, and trumped by the concept of fairness. Even nowadays, as his lordship has put in that one, Justice Pardiwala, that government executes all its what you call policy obligations through now commercial contracts. And it's also been observed in the judgment that the distinction has been blurred now. That of public contract or private contract, that's been blurred now, because invariably 90% of government elections are performed through third-party agencies. If you have this distinction, are they driven to civil court? As you said, we also have to think of the ease of doing business, where people may be feeling shy of coming over here to get a decree and to get it executed through the process of civil court. It's a question of eternity. So under these circumstances, this is the very, very proactive judgment towards the contractual commitments on the part of the state.
Thank you for that passionate argument on your behalf. It is indeed goes to the root of business sentiment in India, and who but the Supreme Court can give us relief when things come to such a pass. I'll go to Manmeet from Saraf and Partners. Now, the KMDA, which is the Kolkata Metropolitan Development Authority, made it clear that it will refund the license fee deposited and the cost incurred by him in the construction activity and maintenance. And of course, he said now that it's been awarded to another party, this original awardee should give up. I want to ask you one thing. Any businessman in this world, when he bids for a public project which has a tenure of 10, 20, 30 years, he has a certain wisdom that even if today it is not profitable, as the usage and the rates goes up, these projects do become profitable. Isn't he entitled to his foresight and his time of bidding? Because whenever we see that public authorities want to wriggle out, they will give many reasons. But the whole wheels of commerce will roll on the basis that the private party has certain foresight, and that's why he invests. Given that as a background, if you could give me your intervention.
So, Tarun, you're absolutely right. I think if anybody who bids for a tender obviously is doing so to make money. Sometimes you make less money, sometimes you make more money. Sometimes your assumptions go wrong, sometimes your assumptions are go wrong in a sense that you end up actually making more money than you had thought that you would, right? Now we are all aware of projects. There are projects in the NCR where I think the issue was how much IRR has the concessionaire made, and some of those matters are sub judice, so I will not comment too much on those. But we should not, as a country, just because somebody has made a very good IRR on a project, feel that now is the time that the contract must be pulled back and the contract must be restored to public hands. Well, he took the risk. He took the risk. He put in the capital. He took the risk when others were not willing to take the same call. And therefore, if we are to encourage investment, we should not feel shy of staying with the contract merely because somebody seems to be 10 years later, 5 years later, making a lot of money. Right. And therefore, I think Supreme Court has very correctly taken that into account, that only because somebody thinks that there could have been some other considerations taken into account at the stage of tender, which could have resulted in far more revenue to the state authority. Well, they could have been taken into account, but they weren't. As long as there is nothing flawed with the tendering process, which calls the tender into question, and merely because some factor which was not available with the authority at the time of tendering, as long as there are no issues of allegations of corruption, there is fair play. The tender, once awarded, should not be interfered with just because somebody is making a lot of money. Justice Naidu, of course, spoke about ease of doing business. We are today competing for capital. Capital is fungible between various countries. We are competing for capital with other jurisdictions, both developed and developing. Similarly, I think if you look at what is the difference why people take the disputes to Singapore or London, the only difference is that those jurisdictions follow a pro-contract approach. Justice delivery is almost, we all have heard of the term software as a service. Justice delivery in these jurisdictions is dispute resolution as a service. So the courts also have to relook at how they have been approaching contractual issues. And the Supreme Court is showing the path. I think there have been other decisions before where the Supreme Court has very clearly indicated the time has come for our judicial system to also look at what is good for the country's development. If enforcing contracts is good for the country's development, it gives confidence to people to put their money here. We all know, Tarun, there are private equity funds which invest in construction projects, which invest in completed projects, but don't take the construction risk. We need investors to come in and take construction risk. We want people to put more and more money into India. And that's only going to be possible once we respect their investment. And that's only possible once you respect the contract. So I think this is a significant judgment which will show direction. As Justice Naidu said, there are decisions on both sides. So how does a High Court judge sitting in 226 jurisdiction decide? I think the path is increasingly becoming clear.
Point well taken. Manmeet, I'll go to Shravan Shankar for his intervention.
Yeah, thank you, Tarun. Thank you, Manmeet. Thank you, sir. Going by the entire compensation idea which was flown in the court hearing, I must say, once the court, the tender was given to a new contractor, the first argument made was it is infructuous. And in alternative, another argument was made that we will compensate him. Now, compensation clause does not surface in the first original tender contract, which was legally awarded. The award which was taken back was lawfully taken, not lawfully taken back. Now, the third thing, the contract does not provide compensation, and also the contract compensation, I am at the mercy of the government to give me compensation at their own wish. They may give me 100 rupees. A 10-year-old contract was taken back in just 2 months. Now, the last thing is profitability. Now, the court also addresses the point of profitability to say that you can always amend the terms of the contract to increase the profitability to the government. The term profitability has two meanings again. Now, there could be real profitability and profitability of part A and part B. Now, the efficiency of reading between the lines makes you understand what is really happening at the ground. There are few occasions where the court actually goes into reading between the lines as to what is happening. But here, what clearly they have very clearly stated with respect to administrative law, a very important statement has been made in the judgment, which I would like to quote. They say that control of administrative discretion is an important concern in the development of rule of law. According to Wade and Forsyth, the rule of law has 4 meanings. One of them is that government should be conducted within a framework of recognized rules and principles which restrict discretionary power. To enthuse efficiency in administration, a balance between accountability and autonomy of action should be carefully maintained. Lastly, they also go into scrutinizing the sanctity of public-private partnership tenders, because that is the way forward, and that has been the way at least in the last 1.5 to 2 decades, where they very clearly state that the government has a duty to ensure that community resources are put to fair and proper use that ensures to the benefit of the public as well. So there has been a very clear demarcation of public-private law and the objective of administrative law and the sanctity of the PPP model. So I think the reading between the lines is sometimes necessary to decode what is really happening.
Very well put, Shravan. The last two lines, when you read between the lines, that is very important. I'll go to Senior Advocate Sheshadri Naidu for his one final comment. Shravan, in his last couple of lines, alluded to public-private partnership contracts. We have private parties investing $3 billion, $2 billion, $500 million in public projects. For example, toll road projects, which are TOT. The latest one is a 36,000 crore project in UP. There are big projects. It's enormous amount of risks that these companies are taking. The traffic may go up, may not go up. The project may be good for the first 5 years, or things may change later, or there will be no traffic in the first 5-7 years. Things may improve only after 7 years. Imagine the amount of a risk a private party takes. And when there are unilateral decisions by the public authority, it erodes a certain kind of business confidence of doing business in India. Given that as a fact, how important is the role of our courts in ensuring that investments continue to flow into India, job creation happens, and India remains a happy place for investment? Your last comment. You're on mute.
Tarun, litigation perhaps is a sign of vibrancy, if I could put it in the lighter vein, but not at the behest of the government. It ought not to be. Even if I remember correctly, recently the Honorable Chief Justice of India has also said that 80% of the litigation is generated by the government, and it could have had exercised some sort of a discretion not to pursue every matter until the end of it, in the sense up to the apex court. Things could have been easy. To that extent, it is true. And you have raised a very pertinent one, that nowadays that fear psychosis has been gripping the investor, especially the contractor, because they invest down the line, something goes wrong, either way, gets cancelled, he gets mired into litigation, it drags on endlessly, and he's been blocked, and then the banks knock at his door, and then IBC stares at him. On one hand, he has to fight to get back his money. On the other, he has to pay to the institutions. There he becomes broke, right? It's a Pyrrhic victory these days for any suitor to get something back from the governmental contracts, which obviously are of high stakes. That's why, just as you said, courts have said that it is a smoke screen as far as the government is concerned when it adopts such techniques. And also, very good expressions have been employed in the judgment, saying that this is a decision on the part of the state or the bureaucracy. And they have said that it is without application of mind, capricious, and also influenced by malice. And also, they have exposed the limitations of a defense in the name of file notings. And it is very categoric. Earlier, there was a bit of judicial swing on either way when it comes to the notings, their efficacy, because they don't contribute to the final decision. It's only a thought of process, and that could not be nailed in any way. But it's been said, once you based your decision on them, they could always be subjected to judicial scrutiny. Now, to round it off, let me quote, long back in 1971, Kerala High Court rendered a judgment, that is P.P. Abu Bakr versus Union of India. And there's been quoted with approval by the Supreme Court in Dilbagh Rai Jerry. And let me quote what's been said by the Kerala High Court, how apt, and it's been appreciated by the Honorable High Court. The state is no ordinary party trying to win a case against one of its own citizens, by hook or by crook. For the state's interest is to meet honest claims, vindicate a substantial defense, and never to see a technical point or overreach a weaker party to avoid a just liability or secure an unfair advantage, simply because legal devices provide such an opportunity. The state is a virtuous litigant and looks with unconcern on immoral forensic successes, so that if on the merits the case is weak, government should show willingness to settle the dispute regardless of prestige and other lesser motivations which move private parties to fight in court. And that's how I feel the state must adopt such a parents' patry approach even towards its contracting partners. A moralistic stand.
Thank you. Thank you for the closing comment. We will take up such issues on it more, but it's time to celebrate when the Supreme Court gives a decision that reinforces the faith of the investor in the India story. This is indeed very important. The quantum of the contract doesn't matter, whether it's of 10, 20, 50 crores, or whether it's of maybe a couple of 100 crores. The important is Supreme Court stood up for what is right and reinforced the faith of the investor and the businessman who takes loan, takes a lot of risk. Ladies and gentlemen, to take a loan of hundreds of crores is not easy. For somebody who takes it, we should celebrate people who do so, because many would not risk such a life. That said, I would like to thank Senior Advocate Sheshadri Naidu, Manmeet from Seraph and Partners, Shravan Shankar, Managing Partner, V. Shankar LLP. Good to see you, and thank you for your time. Thank you so very much.
Thank you very much,
Thank you,
Tarun,
Tarun.
for the
Thank you
opportunity.
very much.
Thank you.
Thank you.
Thank you.